Good afternoon, everyone. I want to get started because we do have a full agenda today. I anticipate that many of them will be fairly expedient, but wanted to make sure that we got started so we could start and end on time and get these bills through this docket. So with that, Madam Secretary, please call the roll.
Representative Blanton, Representative Bratcher, Representative Cantrell, Representative Decker,
Here.
Representative Elliott, Representative Fisher,
Here.
Representative Heverin,
Present.
Representative Cole-Carney.
Present in my annex office.
Thank you, Representative Lewis.
Present in my annex office.
Thank you, Representative Maddox. Representative McCoy.
Here.
Representative Minter.
Here.
Representative Mosier.
Here.
Representative Nemus. Representative Petrie. Representative Scott.
Present.
Representative Stevenson. Representative Banta.
Here in the room.
Chairman Massey.
Here in the room. And today, I'll go through the rules real quickly. Again, if you have electronic devices, please put them to silent or vibrate mode. Be mindful that the technology can pick up the signals, so be very careful with that. Also, when you're presenting, make sure that your green light is on and the mic is close enough to you to be heard. I will tell you we'll have a lot of activity today going in and out of the room because we have several members that are testifying in other committees. I've told them that I may very well hold the meeting open for them to record their votes so that they can make sure that their vote is registered. No signs allowed. I don't see any. And as always, we practice with decorum and civility. So with that, we're going to start with Senate Bill 23, an act relating to theft of mail matter. The sponsor is Senator David Yates.
Mr. Chair, ladies and gentlemen of the committee, thank you for having me today. I have a pretty short, simple, straightforward bill that would include common carriers and delivery services as regards to mail matter. The way we drafted our statute 40 years ago, Kentucky specifically mentioned United States Postal Service. Other states wasn't so narrow. The courts interpreted that to exclude some of the Amazon, FedEx, and things that we see today. Right now, we expect 300 million online shoppers. 91% of the population will have online deliveries. The crime has seen a huge uptick with this type of process. They've caught on because we have a loophole in our law. We see crime syndicates come in. My area in Jefferson County in Louisville has been hit a little bit harder than other places, but I think most elected officials have had victims in their district. Talking to some of my local law enforcement, but also with my neighborhood groups. People catch them on their little ring cameras, and you'll see it over and over. And they'll call and say, "What can I do?" Right now, it's listed as a misdemeanor, Class B misdemeanor in there, and we haven't got a lot of response from detectives and search. What we know is that we have had several rings. Some of them will have the package, the van deliveries that will ping the individual services where they've been put at what household. They get the good stuff. They put it into whether it's a U-Haul truck or bring them back to an apartment they rent. They open up the packages. They find out what they can keep. They sell the stuff that is worth selling, and they go on to the next community to raid. Because of the way it's listed and because of this loophole, they go unchecked, and it's continued to get worse and worse.
We have a motion on the bill by Representative Cantrell, a second by Representative Mosier. I will make one comment and then see if anyone has any questions. I will say the one thing that was brought to my attention after we received this bill, I referred to it as pizza pirates, but basically it's the DoorDash type scenarios too, where people are potentially stealing food and whatnot off doorsteps. We may have to address that in the future. I just wanted to make the sponsor aware that question had arisen. Based on the lateness of the session, we've elected to proceed as is, and I wanted you to be aware of that. But with that, I'm going to look and see if anyone has any questions. Representative Fisher.
Thank you, Mr. Chairman. Under current law, the package has to be delivered to the letterbox, mail receptacle, or other depository, or has been left for collection or delivery adjacent thereto. Are these deliveries to residences on porches? Is that considered adjacent thereto to a letterbox?
Yes, Representative. There is a case directly on point that was published on March 25th, 2021 at the Supreme Court of Kentucky. Davis versus Commonwealth of Kentucky, and they did make a finding of fact that would be precedent that says that the authorized depository means anywhere on or around the recipient's property where such a deposit is specifically directed, and so that would include with that intention.
Seeing no further questions, Madam Secretary, please call the roll.
Representative Banta,
Yes.
Representative Blanton, Representative Bratcher, Representative Cantrell, Representative Decker,
Yes.
Representative Elliott, Representative Fisher,
Yes.
Representative Heverin, Representative Kulkarni.
Yes.
Thank you, Representative Lewis.
Yes.
Thank you, Representative Maddox, Representative McCoy,
Yes.
Representative Minter,
Yes.
Representative Mosier,
Yes.
Representative Nemus, Representative Petrie, Representative Scott,
Chairman, I'm going to be a no today because I typically don't vote yes on adding felonies. Thank you.
Representative Stevenson, Chairman Massey.
Yes. There is 11 yes votes, 1 no vote, and 0 pass. The same will be reported with favorable expression. The same should pass on the House floor. Thank you, Senator, for bringing that bill forward. And I'm sure we'll probably have some other votes with it, but thank you for your presentation today.
Thank you, Chairman. Thank you, committee.
Next, we're going to go to I consider a very important bill that's carried by Chairman Westerfield that I've had the pleasure of working with him on, as well as President Stivers and a number of other folks, and that's Senate Bill 90. And Chairman, you have the floor.
Chairman Massey, I really appreciate that, and I appreciate your effort working on this bill.
I'll get that.
A few years ago, had a conversation with your predecessor, Chairman Petrie. We had assembled a group to talk about bail. Bail is something we've kicked around for a number of years here. You've spent some time on it, Chairman. Chairman Petrie had as well, and so have I. And the conversation took a turn. The first half hour or so, the conversation with the usual stakeholder groups in the justice environment, justice universe, it turned towards substance use issues and behavioral health issues. And the long and short of it was this: everyone in the room, from the prosecution to the defense to the judges to the corrections to whomever else, everyone agreed that the population of people we're most concerned about struggle with substance use disorders, behavioral health disorders, psychological or psychiatric disorders, or some combination of those things. And so you fast forward a couple of years, and we have an opportunity starting last year with the efforts from the Speaker and the Senate President, from then Justice Cabinet Secretary Mary Noble, to bring Pew Charitable Trusts in. Pew spent a lot of time working with us and working with 100 or so different stakeholders and individuals that the chairman and I directed them to. And we came up with what we have in front of us here. Senate Bill 90 proposes a pilot program in no fewer than 10 counties, as determined and picked by the Supreme Court, to establish a behavioral health intervention for our justice population on the low end. So this only applies for people who have a Class D charge. They've got to be a low risk, a low flight risk, a low risk to public safety on the pretrial services assessment. And there are even in that group, there are a number of disqualifying factors. This doesn't cover any DUI charges, nothing from 439, 3401, which is the violent offender 85% statute. If there are IPOs and DVOs involved, those have been excluded. So we've really narrowed it down quite a bit. But the objective is to get this population, if they're eligible, assessed within 72 hours of their arrest by a behavioral health or a mental health expert. Actually, the statute, we use the definition that's been around for a long time, a qualified mental health professional. And that statute covers a whole lot of different professionals. But they are to do an assessment either in the jail by telehealth, which this bill authorizes, or out of custody, though it prioritizes people that are still in pretrial confinement. They do an assessment to determine whether or not they can detect or see any signs of any behavioral health issue. I think everybody agrees that that's usually going to be a substance use disorder in most cases, but it could be something else, something that pretrial services is not equipped or skilled to assess and find. Of those people that are assessed, only those that have an agreement of the parties can get into this deferred prosecution program. That's what this bill creates. In this pilot, if there's an agreement between the prosecution and the defense to go through this and to participate in behavioral health care, that for as long as they are, the case is sort of set on the shelf. We've already got a deferred prosecution program in the state, but it's just deferred prosecution. There's nothing else coupled with it. This requires that deferred prosecution so long as they're participating in this behavioral health intervention. The length of time for that behavioral health course of treatment is determined by the provider. Supervision is done by the provider. I want to get this out of the court system for the sake of this intervention for addressing behavioral health issues. And I'm including substance use disorder, psychological trauma, all that stuff, all under the behavioral health issue umbrella. It's all governed by that provider. It has to last no shorter than a year unless it's by agreement of the parties and the provider, and no longer than the full length of the sentence of the underlying charge that got them in court in the first place. And as long as they're compliant, as long as they're doing what they're supposed to do, if they complete that course of treatment, whatever it is, their case is dismissed. Again, this is by agreement. This is not by court order. I would ask and implore, and the CHFS knows this, Secretary Friedlander has been part of this conversation too, and I think they want this too. As soon as the federal government approves our waiver and courts can order this without fouling up Medicaid eligibility, that'd be super. But since that hasn't happened yet, this is built so that the parties have to agree. The court is not involved in the agreement. They don't order the treatment. They can't. The court can bring the case back up. In fact, the bill specifically says that. The court can set a review and just keep an eye on things. The bill requires that the provider provide regular reporting. First within 14 days, and then 28 days, and then quarterly thereafter, just to make sure that the participants are doing well, but also to collect data. One of the most important parts of the bill is to track how in the world this is doing. Who's participating? Who isn't participating, who agreed, who didn't agree, and why. We want to be able to see at the end of this 4-year pilot whether or not it did any good, and if we have a sample big enough to make that determination. One other important component is we've got some recovery housing language in here. We've got literally, I think, just one line, one sentence that relates to transportation. I'd love to throw a bunch of money at transportation and housing both. We don't have all that money all at once to throw. It's worth every penny, because money we spend here is money we don't spend locking them up and paying for detention in jails or what have you, and much more effectively with this sort of intervention. But we do have a line in there that allows for it if there's an opportunity or funding available. But the other key component is the vocational component. So within 30 days of a participant being entered into this diversion program or this deferred prosecution conditional dismissal program, the workforce cabinet needs to perform an assessment on those participants to see whether or not they can benefit from further education, job training, or even job placement. It even gives some permissive language to allow them to set up an electronic registry to match potential second chance employees with potential second chance hiring companies or individuals if they so choose. All of this, I don't know if I've said it in front of this committee. I know I've said it in front of mine. I know I've said it on the floor of the Senate a number of times. The single biggest thing we can do to prevent people from committing crime again is making sure they've got a job when they get out of custody. I mean, if they're working, they are substantially less likely to break the law and create a new crime victim and tie up the docket and fill another spot in a jail cell that we don't have at an expense we don't want to give or spend. So this is an effort to do that. I'm happy to answer your questions, but that's really the long and short of it.
Motion.
We have to adopt a committee sub first.
We do indeed.
So
I withdraw.
we have a motion on the sub by Representative Mosier. Is there a second?
Second.
Second by Representative Banta. All in favor signify by saying aye. Aye. Opposed? There is none. And before we do a motion on the bill, I do want to thank Chairman Westerfield for a lot of work on this. And I want to thank Roberta, who's here to my right.
Gosh. Y'all, she is fantastic.
And she's had to draft something. We started literally from scratch here.
We did.
And so she was pulling her hair out trying to map this out, this idea, which I think is a very phenomenal idea. And it's in the interest of restorative justice and getting people to work, getting people treatment, and trying to keep them off of our criminal records and trying to keep them out of incarceration that we're all paying for. And so I think it's certainly a noble effort. We're going to do this for at least 10 counties, as we've indicated. The courts have been on board with us on this, and I think this is a big step in that direction. In fact, we've had a couple of bills this session that we've had to amend because we don't want to be contrary to what we're trying to accomplish here. And I know that goes to reduction of some felonies. There has been some felonies added, and I know Representative Scott mentioned it earlier. Our goal is not to be more punitive. Our goal is to try to get people the help and assistance they really need. So I'm hoping that the legal community will really work with this program. With that, that's my comments, but I'm going to ask for a motion on the bill. We have a motion by Representative McCoy. Is there a second? Second by Representative Banta. Are there any questions? Representative Scott? Representative Mosier.
Thank you so much, Chairman. Senator, I know it's not in this bill, but you mentioned second chances. Chairman Massey's talked about getting people employed, getting them to jobs, to work. I know that for years, many of us have tried to move forward second chance legislation around banning the box. Is there anything like that moving that you're aware of that may pass this session?
I'm not aware of anything like that. I haven't seen anything in the Senate. I'm not sure that I've seen anything filed over there, and I know I haven't heard anybody talking about it. But I think that's an important step to take.
I hope that's something that y'all will work on in the future. Thank you. Thank you, Chairman.
Representative Mosier.
Yes, thank you, Mr. Chairman, and thank you, Mr. Chairman, for bringing this legislation. I'm a huge supporter of all the reentry supports that we can put in place. Last year, I passed House Bill 497, which introduced the concept of certificate of employability during incarceration, and so I love this bill. I love really taking those ideas and putting these in some pilots that we can really work out the mechanisms that need to be happening.
Yes, ma'am.
It was just brought to my attention, not just. I've had a few folks who've approached me about digital kind of reentry supports, adding technology to help make those connections, and it would maybe come in the form of reminders about appointments, making those appointments, and I have a couple of really strong ideas about adding something like this, and I honestly, I didn't even, I knew about this bill. I hadn't read it yet until last night. And so I was thinking, oh my gosh, it's a perfect opportunity to maybe add that digital component to these pilots.
Yeah, I wouldn't object to that.
Okay. Well, thank you. I'd love to look at that.
I can't speak for all behavioral health providers. I know a handful of the CMHCs use that sort of scheduling, and it's worked wonders and made things more efficient and improved, I think, attendance with the clients that they already have. So I think that would be, I think it'd fit well.
Okay.
Not going to object to that.
Thank you.
Yes,
all right.
ma'am.
I'll talk to you about that later. Thank you.
Seeing no further questions, Madam Secretary, please call the roll.
Representative Banta,
Yes.
Representative Blanton, Representative Bratcher, Representative Cantrell, Representative Decker,
I appreciate the bill and vote yes.
Thank you.
Representative Elliott, Representative Fisher,
Yes.
Representative Heverin,
Yes.
Representative Kulkarni,
Yes.
Representative Lewis,
Yes.
Representative Maddox, Representative McCoy,
Yes.
Representative Minter,
Briefly explain my vote. I'm delighted to vote yes for this bill that moves the cause of restorative justice forward. Thank you for bringing it.
Thank you.
Representative Mosier,
Yes.
Representative Nemus, Representative Petrie, Representative Scott,
Yes.
Representative Stevenson, Chairman Massey.
Yes. With there being 13 yes votes, 0 no votes, and 0 pass, House or Senate Bill 90, as amended by the House Committee Sub 1, will pass with favorable expression that the same should pass on the House floor. Thank you, Chairman, for this, what I believe, a very phenomenal bill.
Thank you, Chairman.
We're going to move on next to Senate Bill 271, which is also sponsored by Chairman Westerfield. And before he gets into that, there is a committee sub on this as well.
There he is.
Motion on the sub.
We have a motion by Representative Banta. Is there a second?
Second.
Second by Representative Fisher. All in favor of the committee sub, signify by saying aye. Aye. Opposed? There's none. Chairman Westerfield, you may proceed.
Thank you, Mr. Chairman. I I can't take credit for this, and I've given credit where it's due because that's where it belongs every time I've spoken on it. Linda Blackford with the Herald Leader called me several months ago, and she was talking to me about, or asking me questions about some domestic violence things, and she mentioned in the conversation about how KCADV and KSAP are organizations that are advocating for domestic violence issues and sexual assault issues. But the long and short of it was that they basically are using Google News alerts to track data. And that wasn't, I don't think, the point of the phone call, but when she said it, whatever she says, it stunned me. And I think that's a missed opportunity and a blown opportunity. You have, Chairman, others in this body have talked often about the importance of having data to inform our policy decisions. The bill we just voted on that you all just unanimously supported has a data component so we can track its success. We need to track domestic violence, dating violence, interpersonal violence. We need to know what's going on. We need to know about fatalities and near fatalities. We need to know what that picture looks like in the state, and we shouldn't have to use Google News alerts to get it. This bill does that. The committee sub, which I'm grateful you all have adopted, makes some changes that I've continued to need to make and adjust. As I've had conversations with AOC, with state police, and Lexington Sowers here on staff, who's also fantastic, to make sure we get, and CHFS, to make sure we know what's actually gathered right now and what's not. What you have before you is our best effort at getting that picture of data so that going forward we know what the domestic violence landscape looks like.
We have a motion on the bill by Representative Fisher and a second by Representative McCoy. Are there any questions? Madam Secretary, please call the roll.
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Bratcher, Representative Cantrell, Representative Decker,
Yes.
Representative Elliott, Representative Fisher,
Yes.
Representative Hebron.
Yes, and quickly comment. I just want to thank Senator Westerfield for this. Domestic violence is something I think that is it's very important that we talk about here. And if we can get that eradicated, I think it would be wonderful. But as long as we're keeping it as a conversation, I think it's important because it speaks to survivors and victims of that. So thank you so much.
Yes, ma'am.
Representative Cole Carney,
Yes, and thank you very much, Chairman, for bringing this bill.
Representative Lewis,
Yes.
Representative Maddox, Representative McCoy,
Yes.
Representative Minter,
Yes, and great bill today. This is really going to move the needle forward, and I'm so happy to vote for it.
Representative Mosier,
Yes.
Representative Nemus, Representative Petrie, Representative Scott,
Yes.
Representative Stevenson, Chairman Massey.
Yes. There being 13 yes votes, 0 no votes, and 0 pass, Senate Bill 271, as amended by the committee substitute, should pass with favorable consideration on the House floor. Thank you, Chairman. Excellent job, as always.
Thank you.
And thank you for 2 exceptional bills.
Thank you, Chairman. Members, thank you so much.
I believe we still have Senator Carroll with us, so we'll move on to Senate Bill 63, which is sponsored by Senator Carroll. And when you're adjusted there, you can identify yourself and any guest if you have any, and then you can proceed. By the way, while we're waiting for him to get comfortable, there is a committee sub on this as well. We have a motion by Representative McCoy. We have a second by Representative Fisher. All in favor signify by saying aye. Aye. Opposed? There's none. The floor is yours, Senator Carroll.
Thank you, Mr. Chairman and members. It is an honor to be here today. And before I start, I want to just briefly thank Randall Roof with Judiciary staff. I have absolutely worn him out this session, and he has not complained once. And with all the staff, can't thank you enough for all you do. You all are the people that make this place happen, and very much appreciative. Mr. Chairman, this bill is Senate Bill 63 is basically a bill that passed last session. It passed the House floor 64-20. This is a bill that addresses personally identifiable information. It was a bill that Representative Blanton had, and it was combined with language that I had also. This is a bill that we have worked on for numerous years. And rather than go through all the details that I think most of you all are familiar with, I think what I'll do is just cover the changes that I have made, and if there are questions or anything you need to get into further detail on, I will. To begin with, under the definition of immediate family member, I have narrowed this definition down to where it does not cover as many people as it did before. The original version covered expanded family not living in the residence. This bill protects a spouse, child, parent, or person under familial care or custody of a public officer, and those are the only folks who are protected by this language. I would also add that in Section 4, I have put a section in that any public officer who's been convicted or entered a plea of guilty to a felony or criminal offense against a victim who is a minor, as defined in KRS 17500, and the immediate family shall not be entitled to the protections under this bill. And this is new language. So if a public officer has committed a felony or one of these other offenses, they lose their protections. And finally, Mr. Chairman, members, on Section 5, there was language added that is based on the doxing, and I hope I pronounced that right, bill that we passed, I think, last year, and this is similar to that, where it establishes a civil remedy if someone disseminates information that's described as or defined as public publishing, posting, or otherwise disclosing or selling of information, whether electronically, by print, or through any medium for other persons or entities to access or view with no legitimate communication. And for this civil action to be possible, there are three elements that must be met. It's in response to decision or action or to influence or impact any future action taken by the public officer as part of his or her official duties, and with the intent to intimidate, harass, threaten, or alarm, and the dissemination places the public officer or his or her immediate family members in reasonable fear of physical injury or reasonable fear of harm to their property. And that also is new language. If you look in the bill, you can see the members of the criminal justice system who are protected under this bill, and it also shows what information is protected. Mr. Chairman, I'd be happy to answer any questions.
We have a motion on the bill by Representative McCoy. Is there a second by Representative Fisher? We do have someone that has signed up to speak on this bill. So Mr. Abati, is that correct? I say it correct?
That's correct.
From the Kentucky Press Association. If you identify yourself, and you may comment, sir.
Thank you, Mr. Chairman and members of the committee, Senator. I'm here on behalf of the Kentucky Press Association. I serve as one of their outside general counsel. We do strongly oppose this bill for several reasons that we put forward in a statement. I appreciate the committee's busy. I'm only going to focus on two today that we think are the most problematic. The first is that we think this bill is an unconstitutional censorship of press and speech of citizens in your districts. And the second is that it's going to be impossible to administer. On the first point, if you look at the definition of personally identifiable information, it is so broad. It includes the location or the assignment of any of these people. You could not write a news story about a judge or a prosecutor without running the risk that that person might feel that they were put in danger by it and try to sue you for punitive damages, for attorney's fees. Just a handful of examples of stories that have led to systematic reforms that will probably not be published because of self-censorship. The child abuse cases, there's going to be another bill about the child fatality panel right after this. That panel wouldn't exist but for the coverage. That coverage probably couldn't be done today under this bill because of the risk of punitive damages. No-knock warrants and stories about the Breonna Taylor situation in Louisville, we probably couldn't have had those stories. The judge could have sued if she were upset about the coverage of the no-knock warrant she signed. The officers could sue. Tim Longmire, a former assistant attorney general, and his controversy, those stories couldn't have been covered in any way that referenced his position as a public employee. It is so broad, it goes well beyond narrow information that's personal. Secondly, on that point, I just want to point out, we don't think this law will be administrable. New Jersey passed a version of this a few years ago that was touted as a model for this legislation in the last few sessions. It was far narrower than this, and it was so broad for New Jersey, they had to seriously amend it. They had to create a new state agency with a $3 million appropriation in order to administer it, and they had to add new statutory exceptions for things like voter registration, real property documents, candidates for office filings, lien recordings, encumbrances, property tax assessments. Our law has none of those exceptions, and so it's not clear to us how county clerks, how property value administrators can administer this if there's a request for confidentiality. We think it could impede basic functioning of things like title searches, liens, litigation going on in courts. It is so broad, and there's going to be so many unintended consequences that we think that the bill is going to lead to terrible consequences, even apart from being an unconstitutional restriction on speech and an anti-transparency bill. So we stand strongly in opposition to it. I appreciate the committee letting me speak here today, and I would encourage everyone to review our longer statement that lays out other problems with the bill.
We do have a couple of questions, but I always give the sponsor the last word. So,
thank you, Mr. Chairman.
Senator Carroll.
Just to respond, under current law, these records can be released upon order of a court of competent jurisdiction. So these records could be accessed. It just makes it mandatory that they be protected, and that anybody seeking this information goes through the court process. It's already in law. In current language also states that public records containing information of a personal nature where the public disclosure thereof would constitute a clearly unwarranted invasion of personal privacy is protected. So to say it's unconstitutional, it's already in the law. It's already been established. And then in relation to PVA offices and any other entity, a public entity needing to do business, there is a provision in the bill that says nothing in this section prevents a public agency from using PII as required to perform the routine functions of the agency or routine functions necessary to complete business transactions between consumers when the transaction involves a public officer or their immediate family. So those things are covered. And I would remind people, members of this committee, there has been a 400% increase to threats to federal judges in the past 5 years. We've had the highest number of felonious line of duty deaths in the United States for law enforcement since 1995. The need for these protections has never been higher.
With that, we have a question from Representative Blanton.
Thank you, Mr. Chairman. I would ask the gentleman, he mentioned that the judge and the officers in Breonna Taylor case, under personal identifiable information, which is what is included in this, can you point to me, because I'm looking through these, I don't necessarily recall any of that information being released. Can you point to me which one of those personal identifiable information would have impacted them, that they would have been covered under this from what was reported?
Yes. Yes, Representative Blanton, the bill in all the versions, I don't have the committee sub in front of me, but every version I've seen has included employment, location, or assignments, or some version thereof. You can't talk about a judge in the Jefferson Circuit Court without talking about where they work, where they were assigned. You just can't talk about these things. The same with a police officer, that's assigned in the Louisville Metro. Were they on the narcotics task force? Were they on, however you get down into the details of it, you're going to reveal that information. You couldn't talk about a judge deciding a case anywhere from the U.S. Supreme Court all the way down to, the circuit or the district court here in Kentucky without talking about where the judge works, what their role is. And, it's not the mere threat of the lawsuit is what produces the self-censorship. The civil liability provision is new, Senator. You said this is all in there. I'm not aware of a precedent anywhere for civil liability for the release of truthful information lawfully obtained. I think that's unprecedented anywhere. And that information may be public through other sources already. So we're talking about imposing the potential of punitive damages and civil liability because I published information that I could get from LexisNexis or any other source, and you could turn around and sue. And it's not just newspapers, although that's a huge deal. Your constituent could tweet about an interaction with a police officer or a child investigator from CHFS, and they could be upset about it, and that person could sue them for punitive damages. We've never had that kind of liability in this state. And that's a significant encroachment on free speech and press.
First of all, that's a long, twisted attorney response in that there is nothing in the personal identifiable information that I'm looking at on this committee sub to what you just said. So that's a long, twisted answer that diverged from it. Secondly, you mentioned somebody could post something on Twitter. The true details of this bill is that person, the onus falls back on the person looking for the protection of their identity, has to send a letter requesting that that information not be released. And if an individual posted that and they hadn't received the letter not to post, then can you explain to me how that they would be liable?
Yes, Representative Blanton. The provision you're talking about only applies to the new open records exception, which is I don't have the committee sub. It was section 2 or 3 of the old bill. The civil liability provision is not dependent in any way on the person requesting confidentiality. A public official is defined in the bill. Any of their family members could sue somebody that didn't even know that this was the child or the parent or the wife or the husband of a public official for punitive damages, attorney's fees, if just for posting something, whether that person made a request for confidentiality or not, whether they knew or not that person was protected by the bill. This is one of our serious problems with it. We're writing news stories all across the state every day about a whole bunch of people. You know, the reporter may not know that that's the wife of a CHFS, investigator or an administrative law judge. And then all of a sudden that person could turn around and sue. It's gonna lead to real self-censorship. That liability is not dependent on anything other than the person being upset and wanting to sue, whether it's a news story or a tweet.
I respectfully disagree, but that's all in my comments there.
Representative Mentor.
Thank you, Mr. Chair. Question for the bill sponsor. Senator Carroll, New Jersey's law only allows a covered official to redact their home address. Why does Kentucky's bill go so much further?
Just a higher level of protection.
Okay, could you elaborate on that a little bit?
It was just a decision that was consciously made to protect more information. And I think it's in keeping with the times that we live in today based on the statistics that I just reported and other issues going on throughout this country. It's obvious that those working in the criminal justice system are a target at this point, and I think it behooves us to provide additional protections.
Okay. Let me follow that up just a little bit.
Please proceed.
New Jersey, has tried this, and they also recognized that for their law to be workable, they needed to add several exemptions to the law's application, including copies of voter registration files, documents affecting titles to property, UCC filings, petitions naming candidates for office, voting petitions. I mean, a lot of things. So why are similar exceptions not in this bill, given that we know New Jersey was not able to administer this law as originally written?
Those exemptions are in this bill. As I stated earlier, that there's nothing that prevents these public agencies to perform routine functions of the agency or routine functions necessary to complete business transactions involving the protected entities.
Mr. Chair, Mr. Abate is shaking his head. Could we get a response?
I mean, in our view, especially if you look at the way that upon request, somebody has to take down the information that's published on a website. So, for example, the election registry, somebody's contribution history that lists their address, that would have to be proactively removed from the internet. And, it remains to be seen, Senator, how broadly agencies would interpret this routine business function exception and how courts would. But in my experience, agencies err on the side of non-disclosure when there's any question about their own liability. And I think the most likely scenario is what happened in New Jersey is the public agencies simply stopped releasing that information for everybody, as we understand from our colleagues at the New Jersey Press Association. That's why they had to go back in and amend it, because they couldn't tell who was covered by the bill, so they just weren't releasing anything.
Okay. And just to follow up on that, that was a question that I'll now turn into a comment. I did wonder, Senator Carroll, the bill requires KREF to redact the personally identifiable information that KREF gathers when an individual donates to a political campaign. Aren't you concerned this is going to make political corruption easier in Kentucky and make it less transparent?
That would be a normal function of a public agency to publish that information, so I don't think this is an issue. And as far as is the civil liability part of it. It's all based on the intent. So, and media outlets can be sued as it stands today for the things that they publish. So I think there's a certain level of accountability that this bill brings. And the information protected in this is not information that they need to do their story. And if they need the information that bad, there is an avenue to get it that currently exists in the law. In the civil liability, if there has to be some malintent for that to stand true within the civil justice system, and just publishing a story with legally obtained information that does not meet any of these components, there's no judge that's going to rule in favor of someone filing suit for that. So the reality is that the media is never going to support this bill at all, and it's a balance. And I think we have reached that balance that we must provide these protections to the folks listed here. That's just where we are in the world today. And I have, with all due respect to the gentleman here beside me, I have committed to media representatives that if there are unforeseen circumstances that come from this bill, I will work with them to correct it. I have met repeatedly. I'm sure Representative Blanton has met with media representatives repeatedly to try to come to some compromise. And the reality of it is we make changes. We try to help make it more palatable, and it's just never going to happen. I put the section in about if a public official is convicted of a felony, they lose their protections. So I think there has been an effort to make this work. The reality of it is they just don't want the bill, and that's just not going to change.
Thank you. I have some very serious concerns about this bill, but I appreciate your conversation.
Representative Mosier.
Thank you, Mr. Chair. And I appreciate this discussion, and I just have a quick question. I see that this bill pertains only to public officers, and I'm just wondering if there's anything, and maybe I'm just not well enough versed on this issue, but as we're talking about this, it's occurring to me that, public disclosure of information upon any sort of accusation can be greatly damaging to individuals. I'm wondering if there's anything in this bill that would protect an ordinary citizen who is accused of something prior to an actual indictment. I mean, we see that lives are ruined, reputations are ruined, employment and livelihoods are greatly affected by an accusation being published. Is there anything in this bill that protects ordinary citizens?
I think that would come into play under the doxing, and somebody correct me, I cannot ever get the pronunciation of that right. That anti-doxing legislation in the bill that passed, that would fall under those protections. And I think there are some criminal penalties associated with that also, and I think that was Senator Schroeder's bill.
Okay. All right. Thank you.
And I would just add, Representative Moser, that the Kentucky Supreme Court has issued guidance under the existing personal privacy exception that has allowed, for example, police departments to redact the name of individuals investigated but not charged for the reasons you're articulating. So that's already in the current law. In our view, the current personal privacy protections do balance these things already, and we have worked with the senator and are willing to continue working with the senator to try to come up with appropriate compromise language. For example, amending the personal privacy exception for all citizens to include specific listed things here. That was not an acceptable solution. Instead, we have a bill that favors certain classes of people and creates civil liability in a way that we think will lead to serious censorship concerns.
Well, if I may just quickly comment.
You may.
I appreciate that. I would be in favor of that. But simply the ability to redact information after the damage is done is unacceptable. So I would love to see something more about this issue come forward. Thank you.
All right. Seeing no further questions, Madam Secretary, please call the roll.
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Brasher,
Yes.
Representative Cantrell, Representative Decker,
Yes.
Representative Elliott, Representative Fisher,
Yes.
Representative Hebron,
Yes.
Representative Kulkarni,
I'm a pass today because of all the concerns that have been raised. Thank you.
Representative Lewis,
Yes.
Representative Maddox, Representative McCoy,
Yes.
Representative Mincher,
I'm a pass for today because of the concerns that we've brought up.
Representative Mosier,
Yes.
Representative Nemus, Representative Petrie, Representative Scott,
No.
Representative Stevenson, Chairman Massey.
Yes. There being 10 yes votes, 1 no vote, and 3 pass, the same will be reported with favorable expression that the same should pass on the House floor. Senator Carroll, you can stay there if you don't mind. I know you have the hat trick up today. You have 3 on the roll. So we'll proceed now to Senate Bill 97, also sponsored by Senator Carroll. Who's committee step on this one?
I don't think I introduced myself earlier. I'm Danny Carroll, the state senator for the 2nd District.
And I'm Steve Shannon, the executive director of CARP, Association of 11 Regional Mental Health Centers, and a member of the Child Fatality Review Panel.
Alicia Mahoney, executive staff advisor for the Child Fatality and Near Fatality.
Mr. Chairman, I want to apologize to staff. I did not submit the list for the guest, and it was due to a time crunch, and I apologize for that. This bill, Senate Bill 97, addresses the external child fatality and near fatality review panel. Back on October the 14th of 2021, the Program Oversight and Investigations Committee staff presented the annual review of this panel. And through that review, there were lots of issues that came to the surface. And basically what we have is a panel that was established, I think, back in 2013, that a blue ribbon panel in many ways, a lot of expertise on this panel, yet they were very limited in the impact that they were having as a result of the reviews that they have done on these child deaths and near-death situations. So what this bill does, basically, some of the recommendations that the panel has made over recent years are implemented in this bill, and then there was also a process set up to provide some accountability for follow-up with the recommendations that the panel makes. And I'll cover that first, because I think that is really the most important part of the bill. It requires the panel to determine which state agency is responsible for recommendations related to a panel review. And then the panel shall review those recommendations to the agency. The agency shall reply within 90 days with written intent to follow the recommendations or explanations to why they can't. So I think it's very important that you understand that once this is sent out, there's got to be some accountability as to why this is not done, and then there will be follow-up with the appropriate committee if there's legislation that is needed to ensure that these things do take place. Some of the other provisions in the bill, it requires law enforcement to request blood, breath, or urine when the officer has reasonable grounds to believe that the person exercising custodial control or supervision was under the influence of alcohol or drugs at the time of the fatality or near fatality. If the person declines the request, then it's up to the law enforcement officer to seek a search warrant if there is probable cause that exists to get the sample. Then the officer shall follow up with that. There are some requirements to appointment to the board. It adds the president of the Kentucky Coroners Association, addresses the annual report to be published by February the 1st of each year. It gives protections from discovery, subpoena, or introduction of evidence in any civil or criminal action in any manner that would directly or indirectly identify specific persons, cases reviewed by the panel. And the final provision, Mr. Chairman and members, it requires the coroner, upon notification of death of a child under 18, to report the death to law enforcement, DCBS, and the health department immediately, as opposed to as soon as practicable, as it currently is in KRS 72-410. And the purpose of that is to determine the existence of relevant information concerning the case. And the final thing that I'd like to mention, Mr. Chairman, when this committee, this panel was established, there was an MOU with the Justice Cabinet to provide $420,000 in funding annually That MOU was never followed up on, and this panel has not been properly funded through its existence, and there is a proposal in the budget to fully fund them at the $420,000 level. And I can't stress enough the value of this panel. I had the opportunity to sit in on one of the meetings and listen to the review of a few cases. And as a former law enforcement officer and investigator, it would be good to know that someone is watching out and reviewing those cases, because mistakes can be made. Policy can be detrimental to the successful prosecution and the successful handling of these cases before and after the death or near death actually takes place. So a very valuable panel staffed with experts that we need to utilize to its fullest extent, and we hope to continue those efforts as they move forward and as the legislature moves forward as part of the panel. And I will pass it over to Steve for any comments he might.
Again, Steve Shannon with Association of Health Centers. I've served on this for about 6 years, and I tell people this is the hardest thing I do. We spend one afternoon every month reviewing cases that are bad things that have happened to children at the hands of adults, and it's really difficult. I think what this bill does, it allows us to get better data. It allows us to address some of those issues, to understand better, and that's really what we're trying to do, is why did this happen to kids who are in state custody or other referrals from the Department of Public Health? And that's what we want to accomplish, and I think there's a huge number of cases that involve substance abuse, and I think it will help if we can get those, because quite often the drug tests aren't done. We don't know. We sure looks that way as someone who's in the field, but we don't know for sure. So I think this is a great opportunity. We are excited to have a discussion of what the work we do, because in some ways we wondered where it went to, and I think state agencies responding to recommendations is powerful as well. Thank you.
We didn't get your name, ma'am. Are you going to comment here? So
Alicia Mahoney.
we couldn't pick it up on the system. So are you making any comment?
No.
Okay. Representative Cantrell.
Thank you, Mr. Chair. I'd like to ask a quick question about page 4, looks like line 9. The line 8 starts out, if a report includes a child fatality or near fatality and the law enforcement officer has reasonable grounds to believe, and it goes on from there. Reasonable grounds, it's not really a legal standard. We have probable cause, we have reasonable suspicion. Those are more common legal terms. Can you explain the use of this particular term in this instance?
We did discuss using a more common legal term, but you have to remember this is only to ask consent. So really, any level of suspicion whatsoever would be proper to ask consent, because it is an ask. It's not a requirement.
Thank you.
And would those standards apply to 2?
No, the standards are probable cause as far as the search warrant, as I stated earlier.
All right. Seeing no further questions, Madam Secretary, please call the roll.
Representative Banta.
Yes.
Representative Blanton.
Aye.
Representative Bratcher.
Yes.
Representative Cantrell. Representative Decker.
Yes.
Representative Elliott. Representative Fisher.
Yes.
Representative Hebron.
Yes.
Representative Cole Carney.
Yes.
Representative Lewis.
Yes.
Representative Maddox. Representative McCoy.
Yes.
Representative Minter.
Yes.
Representative Mosier.
Quickly explain my vote. I am a yes, and I appreciate very much the updating of this provision. I've been on those calls, those meetings, and it is grueling and heart-wrenching. So anything we can do to improve this system, absolutely, I'm in favor. Thank you.
Representative Nemes.
Yes, thank you, Senator, for bringing it.
Representative Petrie. Representative Scott.
No.
Representative Stevenson. Chairman Massey.
Yes, but we're going to back up for just a moment because we were so awed and inspired by your presentation that we didn't take a motion in a second. We have a motion by Representative Blanton.
That could be important.
We have a second. Second by Representative Fisher. And if nobody's going to change their vote, we have already recorded the votes. And seeing none, then we have 13 yes votes, 1 no vote, and 1 pass. So Senate Bill 97 will pass with favorable expression that the same should pass on the House floor. So thank you, everyone. We will pass Senate Bill 97. With that, we'll go to the final of the trifecta, Senate Bill 179, sponsored by Senator Carroll. And you may proceed, sir.
I can't thank you all enough for hearing all 3 bills. I think in 8 years, this is the first time that's happened and will probably be the last. Senate Bill 179 comes in response to the natural disaster that recently occurred in West Kentucky. As everyone is aware, the tornadoes that came through our area. And in the aftermath of that, and I'm sure it happens in any natural disaster, the flooding that occurred in eastern Kentucky, there are crimes that occur, looting crimes and various other crimes. And the tornado was no exception to this. We had many thefts. I think we even had a murder at the time over in Graves County, if I'm not mistaken, an armed robbery within the area there in Mayfield. So I received a request from one of the officers there in Marshall County in relation to that and some of the issues that they were experiencing. And I think there was also a piece of legislation that came through the House that's very similar to this, related to looting. And when we looked at the bill, we really tried to focus the coverage on these enhanced penalties to strictly cover a declared emergency, but only arising from a natural or man-made disaster. So we couldn't just say natural disaster, because oftentimes disasters can be man-made if someone sets a fire or something of that nature that gets out of control. So we tried to be very specific in the language, and I'll just quickly go through the crimes that it covers. Certain sections of assault third, burglary, criminal trespass, criminal mischief, all the theft charges, and robbery. And basically it's just a 1-degree enhancement in most all of those crimes if it occurs within the area of the declared emergency related to a natural or man-made disaster. And Mr. Chairman, I'll be happy to answer any questions.
We have a motion on the bill by Representative Blanton. Second. We have a second by Representative Banta. All in favor? Representative Cantrell, I'm going to come to you just a second. I do want to thank you, Senator, for bringing this. We actually had drafted a similar bill in the House. We saw that your bill was moving and coming through, so we appreciate that. In light of what happened in Western Kentucky, and having been down there and talked to the sheriff and being told that I think there were 4 people that they caught that had over $10,000 in change on them that they had picked up from the people's homes. That we needed to do something to try to deal with these kind of things. So
cars being stolen.
Correct. There was somebody that brought a trailer, and I think they were loading up cars for scrap, just taking them out of the community. And so that, it's bad enough that people have to go through that, but then to be victimized at the hands of those types of persons is just unacceptable. So I want to personally thank you for bringing this bill. We do have Representative Cantrell as a question.
Thank you, Mr. Chair. And, thank you, Senator Carroll. It's a terrible thing in every way, what your community has been through. I'm looking at, and you spoke to this a little bit when you said that you tried to narrow this as much as you possibly could, so it was limited to a natural disaster such as the tornado. And I'm looking at, it says, unless it occurs, most of these provisions say this, unless it occurs during a declared emergency as defined in KRS 39.020. I'm looking at the definition of declared emergency in 39020, and it says, declared emergency means any incident or situation declared to be an emergency, disaster, or catastrophe by executive order of the governor. And I'm just thinking about that since we've been through COVID-19 and we've had a declared emergency on the books for so long, and now the definition of declared emergency under KRS 39A does not specifically differentiate between a natural disaster such as the tornadoes or a flood and the difference between the emergency as declared by COVID-19 or some other type of disaster. And so when you say you tried to narrowly tailor this as much as possible, and that definition is still so broad, how can we, truly be sure that this is going to apply to the situations when we need it to?
I guess in working with the drafter, just the term of arising from a natural or man-made disaster within the covered area. I would think that would focus and narrow down the incidents substantially. I would think without any question to have to meet those components that there shouldn't be any issues what this covers and what it doesn't.
I hope so too. Thank you.
Thank you.
All right. Seeing no further questions, we have a motion made by Representative Blanton and seconded by Representative Banta. Madam Secretary, please call the roll.
Representative Banta.
Speaker, I'm a yes, but I'd like to thank Senator Carroll for this bill. I just victimization on top of being a victim is something so horrible. So thank you very much.
Representative Blanton.
Aye.
Representative Bratcher.
And I'd like to explain my yes and just say that thank you for 3 great bills, Senator Carroll. Thank you.
Representative Cantrell. Yes. Representative Decker.
Yes.
Representative Elliott. Representative Fisher.
Yes.
Representative Heverin.
Yes.
Representative Kulkarni.
Yes.
Representative Lewis.
Yes.
Representative Maddox. Representative McCoy.
Yes.
Representative Minter.
Briefly explain. I want to thank you as a representative of a tornado affected area where my phone has been ringing off the hook from people who have found their homes looted, dealing with this. It's still going on. It's still going, as you well know. That said, it's a good bill. Can we just double check to make sure that to Representative Cantrell's excellent point, let's just make sure that the language, we've done so much with 39A this session, let's make sure that this will narrowly target the people who are committing these crimes in disaster affected areas. Thank you. It's a yes.
Representative Mosier.
Yes.
Representative Nemes.
Yes.
Representative Petrie. Representative Scott.
Chairman, I just want to explain my vote. Senator, as you heard me say before, I'm committed to being very mindful about voting yes for additional felonies. I made that commitment to my community. So I'm a no today, but that vote may change when it comes to the House floor.
Representative Stevenson. Chairman Massey.
Yes. There being 13 yes votes, 1 no vote, and 1 pass, the same will be reported with favorable expression. The same should pass on the House floor. Thank you, Senator Carroll, for your presentation today.
Mr. Chairman, thank you, and thank the committee so much for hearing these. And I think these are bills that will make a big difference, and I appreciate the support. Thank you.
All right. We are going to have one more bill, and I'm going to call that in a moment. Senator Storm is tied up in a committee meeting. I think I can present the bill for him. But I do want to ask if Representative Blanton wants to record any votes on, I believe it was Senate Bill 23 and Senate Bill 90.
I would like to record ayes on both those.
Okay. And Representative Bratcher, would you like to record a vote on Senate Bill 23, Senate Bill 90, and 271?
Yes on 23, and the others just pass.
And then Representative Nemes, I think we had you down for maybe recording votes on 23, 90, 271, and 63.
I'm a yes on 23, 90, and 271, and a no on 63.
Okay. All right. And did we miss anyone else that needed to record a vote? All right. Seeing none, I'm going to call the last bill. It's Senate Bill 233. I've been asked to carry this on the floor. I'm just going to remain here at the podium. With regards to this bill, this is Senate Bill 233. I will say that it passed unanimously in the Senate Judiciary Committee. We do have some people here that can assist, I suppose. So what I'm going to do is, obviously, I'm Ed Massey, the Judiciary Chair, Boone District 66. I'm going to turn it over to my guest. Senator Storm is in the middle of a very contentious vote, apparently, and said he could not make it here because he had to vote on a bill, particularly right now. So with that, I'll ask the guests to identify themselves.
Cindy Heddleston, Legislative Liaison, Kentucky Department of Corrections. John Dunn, Administrative Coordinator, Kentucky Department of Corrections.
And thank you both for appearing here today. Obviously, it's been referred to us as a DOC reorganization bill. I'm sure that you've worked with Senator Storm with regards to this. So would you care to make some brief comments regarding this particular bill?
Thank you this afternoon. We're pleased to be here. We appreciate it. This reorganization bill is pretty straightforward and simple. It moves a couple of divisions within the Department of Corrections' internal structure. It renames and updates the names for a couple of divisions, and it establishes a new division. Additionally, it modifies the listing of the prison facilities in statute, which can become outdated. At this point in time, I'll turn it over to my colleague.
Motion on the bill.
We have a motion on the bill by Representative Blanton. Is there a second? Second by Representative Heverin and Mosier. Are there any questions? Okay. Representative Nemus.
I understand the changes. What's the practical impact of the changes? Are there any practical impact to the taxpayer, to the inmate, or to what's the practical change?
Well, with the formation of the Compliance Division, what it is doing, it's taking different elements that are in the department under different offices and different divisions, and it's putting it under one umbrella so they're more efficient and more communication amongst those elements doing the auditing and the quality assurance for the department. And it also falls directly under the commissioner's office, while right now these different elements are under different deputy commissioners and different divisions. So this makes it under one umbrella for the department.
And what does that group do?
The group does is they will be doing the auditing or quality assurance for the Prison Rape Elimination Act. They'll be over the safety for the department, which is fire safety, Kentucky OSHA, and federal OSHA standards for the department, and any other statutory requirements when it comes down to safety and fire safety. You have the accreditation branch, which is over all accreditation for all prisons in the Department of Corrections. It will also be over the program credit branch, which will be doing auditing of all programs within the department, which includes prisons, jails, and community centers. And they will also be making sure that inmates are properly credited with any courses they have completed, that they get their actual credit. And they will also be monitoring making sure that the jails get paid under last year's legislation, where when they have offenders complete DOC approved programs, they will get the monetary compensation for doing that.
And so efficiencies in making sure that we put people who are here, there, and everywhere together.
Correct.
To make sure our jails get paid quicker. Will it also designed to get to remove state prisoners from local facilities quicker?
That question, that would fall under an operational thing, but it can be if we make sure that the offenders are getting their credit in a timely manner, then they could in fact get out at when they're supposed to.
And not just get out, but get taken from the
Right.
local facility to the state facility. Because in
Correct.
Louisville, obviously we've got a major problem. We've had 7 deaths in 4 months. We have Lincoln County is overcrowded. There are a number that are overcrowded. We need you guys to take the state prisoners out of the local jails quicker. The law requires it, and I don't know that we're complying with the law right now on the timeline. So how can we push you guys to get those prisoners where they need to be and out of our overcrowded local jails? This won't address that, is what I'm hearing.
Right. That won't address it. No, sir. That
Okay.
falls under a different area.
Thank you.
I will say that during the interim, we had a meeting involving the DOC and dealing with a lot of things, including audits and things of that nature. And I think a lot of this has arose out of things that we learned through that process of trying to make sure that we have accurate numbers and figures and things of that nature to work with. Obviously, there's still some issues that the legislative body is concerned with that we're going to continue to work with you on. And we certainly appreciate your efforts to take positive steps towards making sure that the audit, compliance, all of those kind of things will work more efficiently. So I want to thank you for that, and certainly thank you for being willing to step to the plate in the absence of Senator Storm. So are there any other questions? Seeing none, we have a motion by Representative Blanton and a second by Representative Heverin and Mosier. Madam Secretary, please call the roll.
Representative Banta.
Yes.
Representative Blanton.
Aye.
Representative Bratcher.
Yes.
Representative Cantrell. Yes. Representative Decker.
Yes.
Representative Elliott. Representative Fisher?
Yes.
Representative Hebron?
Yes.
Representative Kulkarni?
Yes.
Representative Lewis?
Yes.
Representative Maddox? Representative McCoy?
Yes.
Representative Mentor?
Yes.
Representative Mosier?
Yes.
Representative Nemus?
Yes.
Representative Petrie? Representative Scott?
Yes.
Representative Stevenson? Chairman Massey?
Yes, there being 15 yes votes, 0 no votes, and 0 pass, the same will be reported with favorable expression that the same should pass on the House floor. So thank you for your presentation today. I just got a text from Senator Storm. He just finished, so he'll probably pass you in the hallway and you can tell him the good news. So with that, the last announcement I'll make is I would like to tell you that this will be our last committee meeting, but I'm not sure that's the case. There has been 2 bills that have been requested from the Senate. I'm working with the appropriate people now to see if we're going to have any kind of a special meeting. If we do, we will let you know. But thank you, everybody, for what I believe has been a very good